Senator Merritt has a question, and you're on number 6.
Yes. Can you hear me?
Yes, I can.
Oh, good. Thank you so much for being with us. I find all this a very interesting constitutional argument. So correct me if I'm wrong here, your argument is that essentially we have a failed election that would require the legislature to step in and assign electors. Am I correct?
Yes.
And what do you say in terms of proving that there's a failed election? What do you say to what's been laid out by our Secretary of State, Governor, Attorney General Barr, and the courts? Because right now there have not been, as far as I'm aware, proof of the number of ballots that would be required to have been problematic to switch the election and call it a failed election. I don't know where the evidence is. What do you say to that?
Well, there are two issues here. There's one, the extent of the fraud in the casting of ballots, and the other, which is undisputed, the failure to comply with the statutory scheme that this legislature has set out. You can say that there's no fraud whatsoever, but if the statutory scheme is not followed, the manner of choosing electors set out by this legislature, which has the sole authority to decide what that manner is not violated. It has been violated, and therefore the election is invalid, even without any evidence of fraud.
Well, can I ask you what is the statutory scheme that, in your opinion, was not followed?
Well, I recited several of the provisions of the state statutes that were not complied with in my testimony.
I don't have your testimony, sir. I apologize.
Yeah, no, that's all right. So I think the biggest one was the change in the signature verification process on absentee ballots. That was done as a result of a settlement agreement. That did not invoke the legislature.
Right.
The problem with that is you had a judiciary and you had executive officials changing the statutory mechanism. The only authority to do that is the legislature.
No, I understand
and the legislature
argument.
did not do that.
I understand the argument. Can I, and I apologize for interrupting. I just want to get sort of the things I'm really focused on answered. So the Secretary of State's position is that the law was not changed. They just, essentially they said this is how we're going to do it to ensure uniformity under the law through guidance to the counties, and the law wasn't changed.
Well, I mean, I've looked at the statute and I've looked at the consent decree, and the consent decree very clearly allows signature verification only of the signature on the application for absentee ballot, whereas the law requires signature verification of both the signature on the application and the signature on file with the registration card.
But sir,
that change from or to and is a significant change.
I do believe that the procedure is you check them both, so there's signature verification 2 times.
Not according to the consent decree. It says or. It says or, and that's a significant change over the statutory scheme. It's only one of the significant changes that I recite in my testimony.
But would you agree that if the procedure is that they check it twice, that's actually preferable?
Yes, that's what the statute requires.
And I believe
but the consent decree allows it to be checked only once. The statute has a double protection there. The consent decree only has a single protection. And that's a change from the statutory protection against fraud that the legislature had adopted that was not complied with.
Well, you and I I'm not sure that's correct. I think it's checked twice. And I think that's what the guidance said. But can we move on? And what else was statutorily not followed that, in your opinion, resulted in a failed election?
Section 21-2-216 on registration of underage voters. They're allowed to do that up to 6 months before they turn 18, if they will be 18 by the time of the election. That was not complied with. People were allowed to register to vote more than a year ahead of their 18th birthday. That looks like more than 66,000 people were illegally allowed to register and vote in violation of that statutory scheme. Felons were allowed to vote in violation of the statutory scheme. The failure to check voter identity was, requirements of state statutes were violated. Those violations of the state statute. And let me give a comparison. In North Carolina in 2018, in the congressional district number 9 there, somebody violated state statutes by doing ballot harvesting that was not allowed under Florida law. Nobody demonstrated or proved that any of those harvested ballots had been illegally cast by people who weren't proper voters. Nevertheless, the violation of the state law was enough for the state election board to order a re-election as a result. I think the same thing has gone here with these violations of the state statutes.
And if I may really briefly wrap it up, yeah, thank you, Mr. Chairman. I'm aware of the North Carolina situation. I think the difference that at least I feel is I haven't seen any evidence of any of the things that you're talking about. So we would need some sort of court intervention, we would need a successful lawsuit, we would need the state elections board to take action the way you described happened in another state. And right now what we have is, in our law, 21-2501F, where the legislature has decreed that the candidate receiving the most votes is who the electors will represent. That's what we have in our law.
But with all due respect, the candidate receiving the most votes in an election conducted in accordance with all the other provisions of your state election law, when that was not done, you don't have a valid election. And this is exactly what happened in Florida when the state Supreme Court started ordering things on recounts that were contrary to state law. The Florida legislature didn't wait for a determination of a court to say our state law was violated. They made that determination themselves and passed resolution to protect their electoral votes. I mean, and it is their sole authority under Article 2 of the Constitution to do that.
So there's a lot of fraud that even the Attorney General of the United States has not found? I'm confused. I'm sorry.
Well, no, you went back to the very first point you made. There doesn't have to be evidence of fraud, although I think there's rampant evidence of fraud, as you've been hearing all day today. The mere violation of your state statutes is sufficient for this to be an invalid election and to return the power to determine the manner of choosing electors to this body.
Senator Jones.
Dr. Eason's Burt Jones, Jackson, Georgia. Appreciate you being here today.